The recent convictions by the Lahore and Faisalabad anti-terrorism courts of opposition leaders stem from the events of the fateful day of 9th May. These convictions rely on a range of tenuous at best reasonings whereby accusations are being made of political victimization and the hounding of the opposition. What happened with the latest judgment dated 31st August 2025 from the Faisalabad Anti-Terrorism Court, whereby 108 members of the opposition were convicted and 75 were acquitted, and resultantly 9 members of the opposition who were elected members were deseated. These judgments, and specifically the Faisalabad judgment, are setting a worrying precedent for the state of human rights and the rule of law in Pakistan. And to get a bit deeper into that, I'd like to go into a deeper dissection of that one judgment in particular. So the Faisalabad Anti-Terrorism Court judgment begins with a narration of the facts of what happened on 9th May. And there is the real facts, and then there is the narration of facts presented in this judgment. You can find some very interesting observations about how our judiciary looks at us from the disparity between the reality and the narration of facts in that judgment. A quick example of that is from the very beginning. One of the first lines, I believe the second or third sentence in the beginning of the narration of facts was, "On the asking of the PTI, the mob became furious." Now, this goes into the territory of sort of a philosophical, sociological based question. Can human beings experience emotions after being asked? Is it not possible that grown adults react differently and get angry or get furious based on their own opinions, their own grievances, their own ideas of what is and what isn't good for their country? The court assumes that on the asking of a political party, on the direction of a political party, individuals became furious, and then they went on to burn things, break buildings, set buildings on fire, set motorcycles on fire, do a great amount of property damage, and assault police officers as well. This all, it appears through the material evidence spoken about in the case, to be true. Several violent protesters did assault police officers. Several violent protesters did cause a lot of property damage on 9th May. And these are all things that under any country's legal system should be punished. What becomes complex, however, is where the judgment goes on into the territory of conjecture and conspiracy, the specific codes of the penal code relating to conspiracy and abetment to mutiny. This is how it targets a range of senior politicians, members of the opposition, and that is what it goes on to discuss. The judgment paints a picture of the events of 9th May being an entirely pre-planned, coordinated, and premeditated Pakistan. Now, in order to dish out punishments like this, a 10-year jail sentence, no different than the people who were on the ground burning things, destroying things, the court needed to rely on physical evidence, as in any criminal law judgment. What evidence did it rely on in this case? There were two supposedly secret meetings. The first of which was held on 5th May at the Rose Hotel at a motorway rest stop in Chakri in Rawalpindi on 5th May, where one secret meeting number 1 took place. And the next was Zaman Park in Lahore, where secret meeting number 2 took place. The judgment posits that in both of these secret meetings, a plan was hatched whereby Mr. Imran Khan stated that if anything is done to me, then we are to commit arson, we are to attack the military, and we are to trigger a sort of revolution and a violent revolution across Pakistan in order to overthrow the government or pressure them for my release. How does the Anti-Terrorism Court Faisalabad know that this was the plan that occurred in those two meetings? It relies on two police officers, witness number 19 and one other witness, who claim explicitly, according to the judgment, that they were eyewitnesses and they heard through their own ears that these words were said within those meetings. Now, naturally, this poses the question, how did these two police officers, a sub-inspector and an inspector, know what happened in high-level political meetings with the former Prime Minister of Pakistan and other leaders of opposition and his entire senior political cadre? Well, the judgment does not tell us. It simply says that these two police officers heard everything, and therefore we know without a shadow of doubt that everyone present in those meetings is guilty of conspiracy. Now, you can use some context and some news and some public statements by these politicians who were in the room, to figure out what actually the court relied on. And a tweet by the former federal minister and one of the people in those meetings, Hamad Azhar, states that the judge relied on the idea that these police officers was hidden under a table and another police officer was hiding behind the curtains. Now, that till date is the only theory we know about how these police officers heard what was said in the meeting. Neither the judgment nor any other source I have come across has posited any other theory as to how police officers were eyewitnesses to the inner workings and inner dealings of a high level meeting of sensitive proportions with the country's leading opposition party and its top political cadre. That is where the evidence comes in. But moving on from the facts and the evidence, the judge decides that he would like to go deeper. How does the judge do that? First, he goes into history, and the history of the subcontinent in particular. The judge compares and reminds us, which still I am yet to understand why the judge would do so in a judgment like this. He reminds us that the provisions of the penal code that he is currently using to send the opposition to jail, this judge calls the famous mutiny of 1857. Now, famous mutiny, mind you, is what a language that the British use to justify what they did in 1857. We do not call it that. People in India, Pakistan, Bangladesh, scholars of the subcontinent, regular people of the subcontinent, we refer to it as our first war of independence. He goes on to explicitly, in his own words, compare the 9th May protesters to the people who protested against the British. Why? The point he's making is that after these additions in the penal code were made, relatively few mass protests occurred in the subcontinent. And once he's done with subcontinental history, the judge moves on to moral philosophy, and not just about 9th May. They moved on and they stated that just based on the fact alone that all of these protests occurred in various cities of Pakistan at once was enough to prove that this was a planned, coordinated, and premeditated series of events. Now, that in itself is a terribly weak argument, because the premise here is that the mere existence of several protests in several cities at once is enough to prove premeditation. Now, if we are to believe that to be true, then when the George Floyd protests happened in America, which were, in the judge's words, exactly similar on facts, mass protests, somewhat violent, occurring in multiple cities at once. Does this mean that the George Floyd protests were all premeditated, had one mastermind behind them that the US government has never been able to uncover? The next example I could think of is the overturning of Nicolae Cruciu in Romania, which was a dictator who was toppled immediately with mass protests occurring in multiple cities in his country because people were angry at his governance. There was no leader. The protest occurred in front of him while he was addressing a mass public rally. And spontaneously, you can see people reacting. They did not like his speech. And spontaneously, the crowd of his own speech turned into the crowd that overthrew him. And going further than that, take even the judge's own example, the example he chose to put before us. In the First War of Independence in 1857, did that have a single mastermind behind it? Was it a conspiracy? No. It is indeed possible that large swaths of people can make their own decision and decide they are angry and they want to be violent or they want to protest. It's an insult to their intelligence, to the intelligence of humanity, to say that human beings are sheep who need to be shepherded and they are not capable of moving or being violent or being cumbersome or irritating to the government without having a mastermind behind them. This one paragraph, I believe it was paragraph 31, it was completely antithetical to any form of common sense even, let alone judicial understanding or legal understanding. And it doesn't stop there even. Things go on to addressing the claims of political victimization, which is a serious claim by the largest opposition party of the country. If they're claiming that all of these judicial proceedings are a farce and they're solely to cause damage to us and punish us and stifle dissent and make sure that we are not able to fulfill the constitutional role of an opposition in this country, all of these claims were described in long detail, that these are the grievances of the parties before us. But they were responded to in only one sentence. And that one sentence towards the end of the paragraph was, if this was really the case, and I'm paraphrasing, if this was really the case that these parties were being victimized, then why are so many members of the PTI not arrested? Now, essentially what the argument being made here is that we are right now choosing to arrest for a decade each over 100 of you, but there's 100 more outside and we're not choosing to arrest them. To which I'm sure the PTI could respond, well, that's because if you could, you would. But right now, every single person in front of you, you're choosing to convict them. All the politicians, they are. And that's why the argument just completely falls flat immediately. Moving on, the judge, coming towards the end of the judgment, comes to the people he would like to acquit. The first of these is Mr. Fawad Chaudhry, who was attending the premiere of the film Money Back Guarantee, starring Fawad Khan and Aisha Umar. The director appeared and said that Mr. Fawad Khan was at my premiere, therefore he wasn't at the meetings. Accepted, acquitted. Then Mr. Zain Qureshi, in his case, the gentleman who had apparently been hiding under a table or curtains, popped up to say, actually, even though I'd named him earlier, on second thought, I think he wasn't really there. I can't confirm his intent. Now, what does this mean in the law? The judge is basically saying that any individual who was present in the room and was confirmed by these apparently masters in disguise, police officers who snuck into the room and so noted down everyone who was there, by virtue of their presence in this room, they are convicted and proven beyond a shadow of doubt to have been engaged in conspiracy. Now, that's a bizarre legal position, to put it mildly. And what it implies is that if conspiracy is occurring in a room, just by virtue of entering that room, you're infected by that conspiracy and you too are liable to be sentenced to 10 years in jail. But what about the people who were serving the tea? What about if somebody walked in and left? It's a meeting of 40 people. Surely most people didn't even get a chance to speak. So are they being sentenced to 10 years in jail for the crime of walking into the room, sitting silently, and then going home? What about the police officer himself who was in the room? Is he not too then guilty for virtue of being in a room where conspiracy was being committed? How on evidence that was vague and unproven to begin with, we have claimed that entire rooms and entire meetings and entire gatherings have been infected, and any attendee to those gatherings is by virtue of their attendance convicted beyond a shadow of doubt. That and the precedent that it sets for future trials is concerning, to say the least. And with that, the judgment ends up convicting 108, acquitting 75, and laying several nails into the coffin of what we think is democracy and freedom of movement and freedom of association in Pakistan.